We will start a PowerPoint presentation on this. Now we start a little bit from the start on this. Now the introduction. As we have known that India is a rule of law, it means that all persons or all laws are apply equally to all persons, and there is a fixed procedure need to be followed when a law is violated. Everyone is equal in the eyes of the law, and fixed procedure is there in the constitution which need to be followed when a law is violated. Anyone who violated the law, for that a fixed procedure has to be adopted by the court. And to enforce this law, we have a judicial system that consists of mechanism of courts that a citizen can approach when a law is violated. So there is a judicial system in the country which has a mechanism of the courts in which the citizen can go approach when the law is violated. And as an organ of the state, the judiciary plays a very crucial role in functioning of India's democracy. It can play this role only because it is independent. That's why they are playing the role. Now, what is the role of the judiciary? The court can take decisions on a very large number of issues. They can say that no teacher can beat a student, or about sharing of river water between states, or they can punish people for particular crimes. The work of the judiciary can be divided into the following. Where is that? Dispute resolution, judicial review, upholding the law and enforcing fundamental rights. These are the three roles which the government has to play. Now, what is dispute resolution? The judicial system provides a mechanism for resolving dispute between citizens and the government, between the two state governments, or between the center and the state governments. So this is the dispute that they can solve this dispute among the people, among the citizen, among the government, between two state government, between the center and the state government, between the citizen and the citizen, and between the citizen and the court and the government. So all these are resolved by the court. Another function is judicial review. As a final interpreter of the constitution, the judiciary also has the power to strike down particular laws passed by the parliament if it believes that these are violations of the basic structure of the constitution, and this is called judicial review. So whatever thing done against the constitution, the Supreme Court or the court has the power to strike that down, saying that that is a violation of the basic structure of the constitution, and that is known as judicial review. In that case, a citizen can also go to the court and ask that this law made by the government is not against the constitution, and you look into the matter. Supreme Court can look into the matter, or if Supreme Court himself come across a law which they think that it is the violation of the basic structure of the constitution, they can take up and study that law. So they can take themselves also, as well as citizen can also go there. Like agriculture bill just now, last month. People thought that it is against the constitution, it is against the welfare of the farmers. Now they have gone to the Supreme Court, and Supreme Court is now studying it and asking the government to submit the reply why this law should not be struck down. So they have to give the reply. The government has to give the law. What is the purpose of the law and what the law says. After that, the Supreme Court will take the decision. So every Indian citizen can approach Supreme Court or High Court if they believe that their fundamental rights have been violated. If your fundamental rights are violated any time, you are free to go to Supreme Court directly or High Court directly, asking them that your fundamental rights should be given to you, because they are the basic rights, compulsory rights. It has to be given to these people. No one can take it back. So it is the work of the Supreme Court to look that people's rights are given or not, or taken away. So if you go to the court, they will ask the government to, or whatever, who has taken your fundamental right, to provide you this fundamental right as soon as possible, without any delay. Now, second topic we read yesterday was what is an independent judiciary. The Indian Constitution protects citizens against the influence of the rich and powerful people by providing for the independence of judiciary. If judiciary has not been independent, there was likely chances that the rich and the powerful will affect the justice system against the poor people. If a poor people go to the court and ask for justice against a powerful person, there are more likely chances that the powerful person will influence the judgment. So that's why independence of judiciary was kept in the constitution, that once judges are appointed, they cannot be removed by the government at any cost, unless and until they have done a serious or heinous crime, and that too by impeachment motion in the parliament by 2/3 majority, has to be passed by the Lok Sabha and the Rajya Sabha both. Then only he can be removed. It is a very difficult procedure. It was done so that they should be feel free to give the judgment against anyone if they found him guilty, because they know that nothing will happen to them. And this is done by the separation of power. It means that other branches of the state, like executive and legislature, cannot interfere in the work of the judiciary. Neither the government nor the executive can interfere in the work of the judiciary. Whatever decision given by them, everyone has to accept, whether the government, whether the executive, whether the common citizen. So that's why they were kept independent, so that they can give the judgment without any fear. The courts are not under the government and do not act on their behalf. Neither they are under the government nor they act on their behalf. They act independently. They give the judgment themselves after listening to the case on its merit. The Supreme Court and the High Court as judges are appointed with very little interference from other branches of the government. Now there is a collegium in which Prime Minister, Law Minister, Leader of the Opposition, and judges are there. Committee is there. The Supreme Court gives the name of the judges, 5 or 6, that these are judges to be appointed. From among them, this committee selects person and appoints them as the judge of the Supreme Court or the High Court. So no other branches interfere in that, neither the government nor the executive. And once appointed, it is very difficult to remove a judge. And it is the independence of the judiciary that allows the court to play a central role in ensuring that there is no misuse of power by the legislature and executive, because now they can give the judgment fearlessly without any fear, because they know that they cannot be removed. No action can be taken against them by anyone, neither the executive nor the government, because they are independent. Once they are appointed, they cannot be removed. Very difficult procedure to remove them. It also plays a very crucial role in protecting the fundamental rights of citizens, because anyone can approach the court if they believe their rights that have been violated. Now you keep in your mind, if your fundamental rights are violated by anyone, you have the right to go to the Supreme Court directly and ask for your right to be restored. Keep in mind, you have these rights: right to freedom, right to equality, right to religion.
Okay, sir.
And if anyone violates your fundamental rights in India, you are free to go to the High Court and Supreme Court to appeal that your rights should be restored as immediately, because these are the basic rights given to every citizen of the country, whether you are living in India or outside India. Now, main structure of the court. There are different levels of courts in India, right from the bottom to the up. There are several courts at the lower level, which is there only at the apex level. At the highest level, that is Supreme Court, is only one. But at the lower level, several courts are there. The court in which the most of the people interact, where the most of the cases goes, are known as subordinate or the district courts. These are the courts which are most busiest courts. They are usually at the district level or tehsil level or in towns.
Sir, which court? Sir, you
And
are
they
saying most busiest court.
subordinate or district court where most of the people goes, because it is the first level of the court. So small cases or whatever cases are going to this court only. After that, it comes higher into the higher court. So they are generally at the tehsil level or at the town, and they hear many kinds of cases. Each state divided into districts, that is states or parts, and they are presided over by a district judge. So this is the court which is most important court, because from here lower court only the case starts. Then it goes to the higher courts. Each state has a high court, which is the highest court of the state. Every state has high court. But some state like Chandigarh or Haryana and Punjab has one only, that is at Chandigarh. Up till now, Hyderabad and Telangana has only one, that is at Hyderabad. In northeast state also, there is one for all northeast states, maybe in Assam. So some two small states together have one high court. Otherwise, every state has high court which is situated in their capital or big cities. Like Rajasthan, it is not in Jaipur capital, it is in Jodhpur high court. But a bench is there in Jaipur. At the top is the Supreme Court, that is located in New Delhi and presided over by the Chief Justice of India. The decision of the lower court is not binding. Neither the decision of High Court is binding on the people. But once Supreme Court gives the decision, everybody has to accept. If lower court gives the decision, you can go to the higher court. If high court gives the decision, you are not satisfied, you can go to the Supreme Court. But once Supreme Court gave the judgment, it is full and final.
Sir, which is the most important court?
So Supreme Court becomes the most important court because the decision of the Supreme Court is final. Once it gives the decision, no one can change it. But lower court, if decision given, you are not satisfied, you can go to the higher court. If higher court also gives the decision against you, you are not satisfied, you can go to the high court. If high court also not give the decision in your favor, you can go to the Supreme Court. But once Supreme Court gave the decision against you or in favor of you, nothing can be done. Only case thing is there that you can submit review petition. You can again ask the Supreme Court to review the judgment again, because I feel something wrong been done with me. In that case, if Supreme Court judges think that it should be reviewed, they can review it. Otherwise, decision given by them is full and final. If someone gives a review petition, it is the jurisdiction of Supreme Court judges to accept it or not to accept. They say we not accept, we do not review our decision again, because whatever decision given is final. But in some cases, Supreme Court reviews it again. They say, okay, we will see. If you are saying that, we will see it, that something can be done in that or not. But the decision of Supreme Court is final. It has to be decided by the Supreme Court to review it or not to review it. So this is like the triangle: district court, then high court, then Supreme Court. Supreme Court is the highest court, which is only one in Delhi. Now we say that in India we have integrated judicial system. That means decision made by the high courts are binding on the lower courts. But the decision of the lower courts are not binding. You can go to the higher court. Another way is through appellate system that exists in India. What this means? This means that a person can appeal to a higher court if they believe that the judgment passed by the lower court is not just. Suppose you went to the lower court against anyone. against the government or against any person or against any institution to the lower court. And lower court gives the judgment after hearing the case against you or against the person against whom you have filed the case. In both the cases, if you are not satisfied with the judgment, you can go to the higher court. If higher court gives the judgment and any one of you are not satisfied, you can go to the more higher court, that is Supreme Court or High Court. The High Court gives the judgment. If still you are, any one of you are not satisfied, you can go to the Supreme Court. But the Supreme Court gives the judgment, it is binding, but lower court judgment is not binding. That's why they say that it is appellate system of judiciary. That means a person can appeal to a higher court if they believe that a judgment by the lower court is not just. That is known as appellate system that exists in India, and all courts are integrated into each other, lower court to the Supreme Court, or are joined together. Sometimes it happens that judgment given by the lower court is accepted by the higher court. He said, okay, whatever judgment given by the lower court is correct. Nothing can be done in that. Then also you can go to the higher court. Or sometimes the higher court says, okay, whatever decision given by lower court was not just. We will see we will review this judgment and we will give the judgment ourselves. So maybe they can change the judgment. A lower court has given judgment against you, but the higher court can give the judgment in favor of you if they think that judgment given by the lower court is not correct. But it happens very, very few times only. Most of the time they accept the judgment of the lower court. They say, okay, whatever judgment given by them is correct. But still you have the option to go to the Supreme Court. But if Supreme Court also says that, then nothing is there. You have to go home and accept the judgment and face the punishment if it is given against you. And if it is given against the opposition of you or opposite of you, then you can enjoy and he will suffer. The Supreme Court judgment is final, binding, but lower court judgment can be challenged in the higher courts. Now in the next topic, in the next class, we read about the different branches of the legal system. Two branches are there, criminal law and civil law. Criminal cases and civil cases. For both, courts are separate. For criminal law, courts are separate. Civil laws, courts are separate. What are criminal laws and what are civil laws? We will read in the next class at still 40 minutes. The criminal law. What is the criminal law? Anyone can read? Prajyoti can read?
In this court means the problems which they give to judge are mostly for crimes.
Now in criminal laws, or the criminal law deals with conduct and acts that law defines as offenses. Whatever the law is defined that these are the offenses, the criminal law conducts and acts that law. For example, theft, chori, harassing a woman to bring more dowry, asking them to bring more dahej, or murder. These are the criminal laws. Other laws are also there, many are there. It usually begins with the lodging of the FIR, first information report with the police, who investigate the crime, and after which a charge sheet is presented in the court. That means a case has been filed in the court. Then court looks into the charge sheet and listens to all the witnesses and all the things, and if he found guilty, the accused can be sent to the jail and also be fined. So generally theft, harassing a woman, murder, dacoity, inflicting injury to the person, these are all come under the criminal law. Asking for more dowry, killing the woman for dowry, these are all comes under the criminal law. We start with the FIR, then police investigate the case, and after that, police present the charge sheet in the court. And according to the charge sheet, the court takes the decision, and if accused is found guilty, he can be sent to the jail and also be fined. So this is the power of the criminal code. Now, civil laws. Civil laws with any harm or injury to the rights of individuals, your fundamental rights have been taken or something has been done against you. For example, dispute relating to the sale of land, purchase of goods, land matters, divorce cases, all this comes under the civil law. Here the petition has to be filed before the civil court by the affected party only. In a rent matter, either the landlord or a tenant can file a case. The rent matter is there and you go to the civil court, only either the tenant or the landlord can file the case directly into the court. The court can give the specific relief asked for instance, in a case between a landlord and a tenant. A court can order the flat to be vacated and pending rent to be paid if it is against the tenant. If it is against the landlord, you can ask the landlord to provide all the services which are required by the tenant. So whatever decision is there, it has to be. But in case a court gives favor in the landlord, they can say ask the tenant that you should vacate the house quickly and pay the pending rent to the landlord as soon as possible with interest. So these are known as the civil laws. So two types of laws are there, civil and as well as criminal laws. Now in this structure of the court, there is a judgment given. One case is discussed. So Rizwan, you read this page number. Page number 58. Page number 58. Second paragraph. Let us understand what we mean by the appellate system by tracking a case. Now this case has explained about the appellate system, that is lower to the higher court. Second paragraph.
58, second paragraph. Let us understand what we mean by appellate system by tracking a case. State Delhi Administration versus Lakshman Kumar and others, 1985, from the lower courts to the Supreme Court. In February 1980, Lakshman Kumar married 20-year-old Sudha Goyal, and they lived in a flat in Delhi with Lakshman's brothers and their families. On 2nd September 1980, Sudha died in hospital due to burns. Her family filed a case in court. When this case was heard in the trial court, four of her neighbors were called in as witness. They stated that on the night of December 1, they had heard Sudha scream and had forced their way into Lakshman's flat. There they saw Sudha standing with her sari in flames. They extinguished the fire by wrapping Sudha in a gunny bag and a blanket. Sudha told them that her mother-in-law Shakuntala had poured kerosene oil on her and that her husband Lakshman had lit the fire. During the trial, members of Sudha's family and a neighbor stated that Sudha had been subjected to torture by her in-laws and that they were demanding more cash, a scooter, and a fridge on the birth of the first child. As part of their defense, Lakshman and his mother stated that Sudha's sari had accidentally caught fire while she was heating milk. On the basis of this and the other evidence, the trial court convicted Lakshman, his mother Shakuntala, and his brother-in-law Subhash Chandra and sentenced all three of them to death. In November 1983, the three accused went to the High Court to appeal
Accused.
against the
The
verdict
accused.
of the trial court. The High Court, after the three accused went to the High Court to appeal against this verdict of the trial court. The High Court, after hearing the arguments of all the lawyers, decided that Sudha had died due to an accidental fire caused by the kerosene stove. Lakshman, Shakuntala, and Subhash Chandra was
Acquitted.
acquitted.
Acquitted means they were left, they were freed.
Acquitted.
They said nothing is happening. It was accidentally caught the sadi of the, and it did not die with the kerosene stove caused the death. So they said that all three are not guilty and they freed them. He said they should be freed. And now start.
You may remember the photo essay on the women's movement in your class 7 book. You read about how in the 1980s, women's groups across the country spoke out against dowry deaths. They protested against the failure of courts to bring these cases to justice. The above High Court judgment deeply troubled women and they held demonstration and filed a separate appeal against this High Court decision in Supreme Court through the Indian Federation of Women Lawyers. In 1985, the Supreme Court heard this appeal against the acquittal of Lakshman and the two members of his family. The Supreme Court heard the arguments of lawyers and reached a decision that was different from that of the High Court. They found Lakshman and his mother guilty but acquitted the brother-in-law Subhas because they did not have enough evidence against him. The Supreme Court decided to send the accused to prison for life.
This was the system. That Lakshman was there, married to Sudha Goyal. They were living in a flat in Delhi with Lakshman brother and families. On 2nd December 1980, Sudha died in hospital due to burns. Her family filed a case in the court, lower court that is. And when this case was heard in the trial court, the neighbors were called as a witness because it was the neighbors who doused the fire. The neighbors were called as a witness. And they stated that on the night of 1st December, they had heard Sudha scream and they forced their way into Lakshman's house flat and they saw Sudha standing with her sari in flame. They extinguished the fire by wrapping Sudha in a gunny bag and blanket. And Sudha told them that his mother-in-law poured the kerosene and his husband had lit the fire. And during the trial, members of Sudha family and the neighbors also said that Sudha was subjected to torture by the in-laws and they were demanding fridge, scooter, cash after the birth of his first child. As a part of the defense, Lakshman and mother said that they were not poured the kerosene, they had not lit the fire. It was accidentally Sari caught the fire by the stove and she died. But the trial court, after listening the case, decided that the Lakshman and his mother-in-law and Shakuntala, his mother and Shakuntala and his brother-in-law Subhash Chandra are guilty of burning his Sudha, and they convicted him and then sent to life, give them the punishment of death, to be hanged till death. So by the trial court, they were not satisfied. Sudha and Lakshman and brother-in-law were not satisfied with the case, and they called the High Court in an appeal in November 1983 against the verdict of the trial court. High Court, after hearing the arguments of the lawyers, decided that Sudha died accidentally. Sadi caught the stove and she died by the burning, and he said all three are not guilty and they acquitted him. They should be let free. But the women associations were not satisfied with the decision. So they appealed in the Supreme Court. In 1985, Supreme Court heard this appeal against the acquittal of Lakshman and Sudha and his brother-in-law Subhash. Supreme Court heard the argument of the lawyers and all the evidences and other things, what trial court said, what the High Court said. what the evidences, witnesses said. After hearing all these things, arguments, they reached a decision that the decision of the High Court was not correct. What the trial court said was the correct, but the High Court decision was not correct. They have bypassed something, but they have bypassed some evidences. And they found Lakshman and his mother guilty of killing his daughter-in-law, but acquitted the brother-in-law Subhash Chandra because evidence was not enough. Evidence was not there to prove that Subhash Chandra was also there or who was involved in killing of the Sudha. So Supreme Court let Subhash Chandra free, but he found his mother Lakshman and his mother guilty and sent them to the prison for life. They were given the life imprisonment. In this case, they said no, nothing. They were wrong. It was not accidental. They tried to burn her. And he overturned the decision of the lower court of death sentence to life imprisonment. He said to go to the life imprisonment. They will put to the life imprisonment means for 14 years. If anyone given the life imprisonment punishment, that means he has to be in jail for 14 years. After 14 years, he will be let free
Jail.
from jail. But up to 40 years, if life imprisonment is given, he will be in jail for 14 years. But they can appeal to the president
Sir, how?
to get them to get their sentence less.
Sir,
If
for
president,
president,
if president
sir,
says
voting
then
is
if president
compulsory,
says,
right?